Resuming debate, the honourable member for Cowichan-Malahat-Langford.
Thank you very much, Madam Speaker. It's indeed a very great pleasure to rise today to debate Bill C-415, brought in by my honourable colleague and friend from Victoria. We both hail from Vancouver Island, and I really just very much admire the work that he's put into this bill, because it's not very often that you get to debate a private member's bill in this place that really has such significance for changing how we approach the criminal law and acknowledging past wrongs. You know, one other private member's bill I can reference, which I think had a major impact, was Bill S-201, which was brought in by Senator James Cowan, which recognized genetic non-discrimination. And the Liberal cabinet had a position against that bill, but virtually the entire Liberal backbench rose up and disagreed with the cabinet and voted in favour of that bill. And so with the combination of the Liberal backbench, the Conservatives, the New Democrats, we actually passed that bill. It received royal assent. And I very much implore my Liberal colleagues, I know some have raised some concerns with this bill, but I implore them to look at what is being attempted through this bill. They may not think it's perfect, but at the second reading stage of a bill, we're acknowledging the intent of the bill, and I think very much that if they look into their hearts, they will find some worthiness in at least sending this bill to the Standing Committee on Justice and Human Rights, where we can hear from departmental officials, where we can hear from expert witnesses, many of whom the member from Victoria has already quoted. And that's where we can actually look at the language, the technical jargon of the bill, to see if some of those concerns can be addressed. But let us at least send this bill to committee, because I think this is a very important moment. Madam Speaker, last year I had the pleasure of giving the NDP's response speech at second reading to Bill C-45 in my capacity then as the Justice Critic. And you know, I acknowledge the bill was not a perfect bill, and there was a lot of very fulsome debate on the merits of that bill. I think my colleague, the member for Vancouver Kingsway, said it right when the bill C-45 didn't really legalize cannabis; it just made it less illegal, because the possession, there's some very strict limits that even if you step outside of those bounds, the full weight of the law is going to still come upon you. But nevertheless, I think even my Conservative colleagues can realize that there has been a sea change in public opinion in Canada with regards to cannabis possession. There was a very real realization that the continued criminalized approach to cannabis possession was wrong. Far too many people were suffering under it, and in fact the continued criminal approach was actually causing more harm than the prohibition of than the actual use of the drug itself, and there was that recognition. And indeed, when you look at many of the arguments that Liberal members made in support of C-45, not the least of which was the Minister of Justice, one of the big reasons they cited was the fact that thousands of Canadians end up with criminal records for a non-violent minor cannabis offence each year. In fact, I'll quote her, Madam Speaker. In her second reading speech on C-45, the Minister of Justice said, and I quote, "A majority of Canadians no longer believe that simple possession of small amounts of cannabis should be subject to harsh criminal sanctions, which can have lifelong impacts for individuals and take up precious resources in our criminal justice system. Our government agrees that there is a better approach," end quote. Madam Speaker, I could not agree more with what the Minister of Justice said last year during the second reading debate on this. Now, there are roughly 500,000 Canadians who have criminal records for cannabis suspension or cannabis possession. So that means, Madam Speaker, if you took a room of 60 people, one person in that room is probably going to have a record for cannabis suspension. And, you know, I think when we acknowledge that that's pretty far-reaching, the consequences that it indeed has. We know that it has affected marginalized and racialized populations disproportionately more than average Caucasian Canadians, and that is borne out by the evidence collected in each province and many of our major cities. But also another big issue, too, is that, you know, this government came to power with a promise to legalize cannabis, and in fact it was adopted in a 2012 Liberal Policy Convention. So I think the Canadian public has known for quite some time that this was coming. Like my friend, the member for Edmonton St. Albert Edmonton said, elections have consequences, and the Liberal government did fulfill that one promise. However, I have issue with the length of time that it took. We needed the task force to present its report. We then finally had C-415 introduced in April of 2017, and it did receive royal assent and came into force only on October 17th of this year. There was plenty of time for the Liberal government to deliberate on this subject, on the consequences that criminal possessions have for people's lives, where you have this strange binary situation where a person who possessed cannabis on October 16th received a criminal record, but a person who had it on October 17th was perfectly fine. It is quite amazing what has happened in this country. Like you can now possess up to 30 grams in public. People can now grow their own plants, because even though there are still very real consequences with the over-consumption of cannabis, whether it's getting into the hands of children, I think we can very much agree that the continued criminal approach to the issue was wrong. It was using up precious resources, and it was in no way effectively dealing with the problem. And Madam Speaker, when you look at the intent of C-415, I very much admire the word expungement, because it has an air of permanence about it. It is very much different from a record suspension, because as the member for Victoria very clearly laid out, a record suspension is simply setting aside the record. It does not protect the individual in any way from having that reapplied sometime in the future, and indeed, they very much have to prove that they are worthy of its happening. And expungement allows that individual to actually truthfully answer a question that they do not have a criminal record, because expungement makes it as if it never happened in the first place. Now, I know that, and when you look at the statistics, Madam Speaker, specifically with reference to Indigenous people in Canada, in Vancouver, Indigenous people were 7 times more likely than white people to be arrested. In Regina, it was as high as 9 times. So if we're trying to address a historical wrong, a very real case of social injustice, I think expungement is absolutely the way we should be going. And Madam Speaker, I know the Liberals have raised concerns. They have said that they wish to reserve expungement for activities that have been found unconstitutional. And the parliamentary secretary made reference to Bill C-66, which absolutely every member in this House was supportive of. But the member for Victoria, I have to repeat this, it was clearly outlined that the reserving expungement for activities that have been found unconstitutional is simply an arbitrary distinction. It has no legal or principled foundation. This is basically a government making up its own rules, and I asked them to point to any specific case law that underlies their arguments for this, because trust me, Madam Speaker, they will not be able to find that. They also would like to say that pardoning people will work because they're going to make pardons free and immediate. I appreciate the fact that the application process will be removed and that the fee will be waived, but right now the only legislation that actually exists on the books to address this issue, right now at the very end of 2018, 3 years into this government's mandate, is the member of Victoria's Bill C-415. And they also, Madam Speaker, agree that the process needs to be fair, but they have other doubts about the bill. This bill has been consulted widely with academics and members of the legal community. I again appeal to my Liberal colleagues to not throw the baby out with the bathwater. If they do have difficulties with the technical aspects of this bill, with the language, surely they can understand the intent behind this bill. Surely they can find it within their hearts to send this bill to the Standing Committee on Justice and Human Rights, where we can do the necessary amendments so that it comes back to this House, reported back to this House in a form that they can support. So, Madam Speaker, I look forward to voting on this bill, and again, I congratulate my friend and colleague from Victoria for bringing in this fantastic piece of legislation.